of years, the mind absorbs the information easily, completely free of doubt. That is the reason our ancient schools we were taught by our gurus. There were no books. They were only preachings in the morning from 5:30, maybe around 1 o'clock. From 3 o'clock to 5 o'clock there was different session. So that started from the age of 6. That was very easy because what we hear will be observed. So nectar of years, the mind will be observing. So you need not write anything. I'll be only giving you a bird's eye view, how to deal. You go home whenever the occasion is very much necessary in these days. Easily you are getting judgments, but when we started, me and many members are there here. We started, we didn't have this technology. We are having all manuals. Traffic was not there when we come to this court. Maybe we had little time more than you. I'm only talking about the young advocates, not the seasoned advocates. You have no, because all the you come from distant places. A good homework will excel you. Go to the judge, never beg justice. You are an able advocate. First section would be the extent of the act or what is the scope of the act. It will define, every statute will be there. Then when you go to section 2, definitions part, when we are dealing with civil procedure code, section 2, what is the degree? That point to start. A decree is an enforceable part of a judgment, operative part of a judgment. That is executable. Many of my friends, if I am right, they might have gone to the civil court to file an EP. There you need not file a judgment. A certified copy of EC decree is enough to get through. To file an application under Order 21, maybe for a sale of the property. A court from entertaining a suit on the very same cause of action when the same is already pending in an older suit between the same party. If a suit for the same relief it's pending, then a subsequent suit there is a bar, because already the matter is sub judice, what we call. These three terms, sub judice, res integra, and res judicata. These three things, I know many of the seniors might have already come across, and you young minds were already done that. What would happen is, little bit, you should know what is the difference between sub judice, res integra, and res judicata. Section 11 is res judicata. For the same relief, for example, there was already, it was decided on merits of the case, not as dismissed for non-prosecution. If it is decided on merits between the same parties for the same issue, then there is a bar. Subsequently, you cannot file any suit for the very same relief. Then therefore, if somebody A files a suit against B, it's already decreed or dismissed. If again he files one, he section 11, therefore the suit is not maintainable. File an application for rejection of the claim. Normally it will be. There are instances where it should be dealt. The provisions are there. And next section, court is there. You are conscious under CPC, junior civil judge, senior civil judge, then a district judge. Then you wanted to file a suit. There are two types of jurisdictions. One is pecuniary jurisdiction, other is a territorial jurisdiction, right? I'm happy that all of you know it. Pecuniary jurisdiction, can you file a suit immediately before a district judge? No. The subject property, for example, is 5 lakhs. The jurisdiction prescribed, because High Court is the rule-making authority. Rule-making authority has made it clear that up to 10 lakhs, it's the pecuniary jurisdiction of a junior civil judge. From 10 to 50 lakhs is the senior civil judge. Unlimited
up to unlimited will be district judge. Maybe commercial litigation, commercial suits, I'm not talking. Let us not go to that. Commercial act is a different one. Though the procedure is very same, CPs is applicable there. Jurisdiction of the suits and conducting of proceedings is a different. We'll come to the latter point. Now immediately one should know, how is a pecuniary jurisdiction decided, sir? Why? How can I say it's 10 lakhs only? What would be the basis? Yes, then your mind started tickling, just started working. Then 10 lakhs. How should I know that property is 10 lakhs? Yes, sub-registrars go to the sub-registrar, file, and that time, if I'm right, it was 50 or 100 rupees. Maybe it has been enhanced, if I'm right. File a valuation certificate there. They will give you value. Get that along with the plaint. You say, this is the valuation of the sub-registrar's office. Yes, the suit is maintainable before this civil judge. The suit has to be filed before the concerned court having the pecuniary jurisdiction. Then after 15, section 24 for a property, and B suits A, maybe one of the properties included. Then there will be multiplicity of proceedings. What you will do? One court will be at Vikarabad, one court will be at Shevalya, because two properties have been included. To avoid multiplicity, section 24 is there. Then file an application. If it is interstate district, file before the district judge concerned. If it is between the district, file an application here. You all know it. I'm only just giving it. Then power of Honorable Supreme Court to transfer the cases from one high court to other high court, section 25. Then would be, what is section 26? Now, this is very important issue where, how would the suit start its trial? All of us know, you all know, section 26 defines a plaint. That is a substantial section. Then comes order 7. Order 7 is only procedural one. What are the particulars to be stated in the plaint? How the plaint should be written is the procedure based order 7. But substantially, when you file a plaint before the court, it starts, the suit is said to be started. Then comes the stages. Maybe all of you know what is the stage, presentation of the plaint. Then comes notice will be ordered, the defendant it will be served, summons will be served. Thereafter he comes, written statement under order 8 will be filed. Thereafter, one more time, what will happen is, if there is any possibility, there will be a possibility, we cannot rule out. 1 out of, may say, 1,000 cases, there will be chances the court will put it for consideration. That is also there. Only to see whether the suit is settled at first instance, to see that justice is done. Next would be the judgment and decree. That you don't worry, we'll take care of. How would be the judgment? You study it, but there are suits to be filed against government. Please keep in mind, filing suits against the government, routinely please don't file. See that who is a title over the said property. When you are filing a suit of the government, section 79 says, how should a state government or the union government be represented? You should say state of Telangana, represented by the secretary, the concerned department. That is the first defendant. Thereafter, you can include whether the Tahsildar or any other authority who will dispute your title. That is foremost important for you. Or section 79 also says that a district collector can represent the state, provided the caste title should be the state of Telangana or government of Telangana, represented by the district collector. Because district collector, as all you know, that is a custodian of the revenue records. He is the highest authority in a district. Please keep it in mind when you are filing suits against the government. It should be properly done. 79, and after that, when you are filing a suit, can you file straight away like a private parties? No. There is a mandate requirement. Section 80 says what you should sue. Give a notice to the government. Again, when you are issuing the notice, say to so and so the government of Telangana, represented by secretariat buildings are so, or the district collector, represented by district collector, wherever district, issue a notice requiring him to answer it within 60 days. Failing which, will be constrained to file a suit, or you are proposing to file a suit. Then there will be no lock-in. If you don't issue section 80's notice, the suit will not be maintainable. Per se, it will be written to comply such a jurisdiction. Or inadvertently, if it is numbered, even at latter point, maybe around 7 to 8 years also. But routinely, what will happen before we all know when we go to the court, civil court, they have more pendency. They will not open the file. They will only go by the steps. What is the step? Unless you bring it to their knowledge, unless the defendant counsel or the plaintiff counsel who has not properly read brings it to notice of the court, it will not open the file. If it is not filed properly, end of the 7 years, 8 years, if there is no lacuna, it will be written for proper. Or if the written statement, there is a contention raised, the suit is not properly maintained, properly filed, framed by the plaintiff. It has to be written. Then it will be written. What would happen? All those, you lost very good time of 3 years or 4 years, whatever it is, 1 year, 6 months valuable time. So please keep in mind of that. Next would be section 89. I said when the suit is filed, written statement is also filed. Since there is a chance, there may be a chance. Bleak chance, definitely yes. It will be referred for mediation, or it will be posted for the stage of consideration. Consideration, normally if it is not feasible, again the next step after filing of the written statement would be settling of issues. Issues will be settled. If you are not satisfied with the settling of the issue by the court, you can have one more. The plaintiff or the defendant can file a memo or an affidavit saying that this issue also should be framed. That is called recasting of issues. You can do that because in a civil court trial, the defendants or plaintiff will be adducing evidence in respect of particular issues only. The issue is not properly framed. Substantially, for a partition suit, one relief, whether the plaintiff is entitled for the partition, it covers everything. Their declaration also can be made. In that, please be careful. You should file an application for recasting. Next would be as you all know, we will be dealing all with first appeals. How will the first appeal start? What is the provision? You all know that again, and not just only for better, just memorizing your thoughts. I'm 96. The first appeal will be filed under the provision of section 96. You need not say order 41. Say, I am filing the appeal under section 96. That is enough. First appellate court power will start from there. What is 41 then? The 41 is the manner by which the appeal has to be provided. When we are dealing with 96, it's institution of appeal. 26 is a plaint. 96 is a first appeal. Then 41 is a procedure. How the procedure? What is the procedure to be followed when an appeal is filed? 41 deals says, all the provisions says, the appeal as filed by the plaintiff or the defendant is a continuation of the suit. That is your valuable right. One more right, if the learned trial court judge has not dealt the issue properly, or not considered the evidence properly, not considered the law properly, not given the findings properly, attack the findings, say that the finding of so and so specifically are perverse, untenable. The learned judge does not properly appreciate it. You can attack the finding, but sweetly. It should not be harsh when we go to the court. We know we commit mistakes, but it should be pointed out properly. We do understand when we point out mistakes, we should also address you in the same way. The same, like beggars, like we give you respect, you will give you respect. Provided when you open a case, first word should be, yes, this is an appeal filed by the plaintiff. That will clinch your issue. Judge will feel happy that yes, the counsel who is dealing with the appeal is conversive with the civil procedure. You always win by a reason. Don't go by harsh, you're not going to. But by a reason, you're always winning. Then 41 says, what are the provisions? It should be dealt as a suit. And one more important factual issue is Order 41, Rule 27. That's a very, very good weapon in your hands in first appeal. What does it say? For example, if a document was not available for you at the time of the trial or at the time of institution of the suit, document came later, it was not marked. Generally in appeal, when we say continuation of a suit, it will be dealt basing on the documents filed before the trial court. If you are not filed it, what is my recourse, sir? I have got a very good document where it would clinch my issue. The plaintiff would win or the defendant will win. Then upper recourse will be file an application under Order 41, Rule 27. You say why it was not filed. Now it's a trite law. It has been already upheld by the Honorable Supreme Court. When you file an application under 41, Rule 27, mechanically it cannot be dealt. And that shall be dealt along with the appeal itself. When we hear the main appeal, that application will be considered. Now it's no longer res integra. That is, now it's a trite law. That application will be considered after you argue the appeal. When the court feels that yes, this document is very much necessary for a party, then what will happen? 41-27 is allowed. At the same time, Honorable Supreme Court said, you hear the first appeal also. First appeal is also heard. Then we were about to pass the judgment dismissing an appeal or set aside, reversing the findings of the learned trial court. What will do? Then 41, 28, 20, Rule 29 will come into picture. We can direct the trial court, remand the matter to only that extent of the document. Because the party against whom you are relaying the document should be given a fair opportunity under Rule 28 and 29. Only to that issue we will remand it to be considered by the learned trial court judge with a observation that the party defendant or plaintiff shall be at liberty to cross-examine. The document will be marked and cross-examination will be recorded. That part will come before the first appellate court. It will get tagged on to the evidence with the first appellate court. Finding will not be there. Finding, then we said it's a continuation of a suit. Yes. Then that cross-examination along with the document is already marked. Then we pass an order in the first appeal. So friends, be cautious if a document is there. You had a document, but it's settled law. What was not available at the time of trial of the suit, you did not file it. You wake up for slumber of maybe around 10 years or 12 years. If you file it, it's a futile exercise. Even because the Honorable Supreme Court said reason should be there. What was the reason for not filing it during the course of trial should also be properly explained. So friends, be cautious when you file such application. Next provision, you all know, day in and day out you lead. Section 100, second appeal. When a second appeal is filed, how it should be drafted. When we came, casually I drafted a second appeal. It came before one of the best judges we had, Honorable Justice Bilal Najki. Because I drafted it, my senior told me, you go and appear, argue the matter. I didn't have any guts to go before the Honorable Judge. I started the matter. He is from Jammu Kashmir. He had a slang. Said, ah. And immediately I just felt nervous. Then he immediately, have you read section 100? I said, sir, section 100 I read. Then what is the purport of section 100, gentlemen? I was a blank. Read again. Have you got CPC? Initial days, oddly around 2.5 years. I read, sir, but did not get the book. He has passed on the book. Gentlemen, read that. Yes. Then you understood it. I did not understand, sir. He openly told. It's not a factual appeal. It's not a first appeal. You're dealing under the provisions of section 100. You should frame a substantial question of law. Unless there is a substantial question of law, the second appeal cannot be taken. I don't know how the registry has numbered it. Immediately I said, I apologize, sir, I'll stand corrected. I went to my senior. I asked him, yes, you have done mistake, rectify it, frame a substantial question of law. Then I asked him, what would be the substantial question of law to be framed? Because both courts we have lost. There are concurrent findings. A suit for title was lost in the land before the land trial court judge. After the first appeal also we lost. What would be the substantial question of law? That dispute was in respect of a lane. Property was valuable. It was probably in Banjara. A senior told me, you study the board judgments 2 or 3 times. Thereafter, you will be knowing. Then you come to me. Then I read it. I could not get it. Then was there any perversity of findings between the two courts? I didn't say perversity was there, but I said, yes, sir, the reasoning adopted by the first appellate court was not proper to my little knowledge. And yes, frame that. Say, there is perversity of findings by the learned first appellate court. The issue was not dealt properly. Frame that, file it, you test it. I filed it. It came after 1 month. Maybe provisions have changed. It gone before the next civil admission court. Fortunately, that was taken into, it was admitted. So friends, when you are filing a second appeal, you all know you have been doing wonders, but be cautious when you are drafting section 100 appeal. Then previous days, many of you were there, if I'm right, letter patent appeal was there, LPS. Even against the first appeal dismissal, we used to file a LPA. There was huge pendency before the division benches throughout country. Then that provision under A came. What is that? There is a bar. There's learned single judge order. There cannot be any further appeal, be it a letter patent appeal before a division bench. That provision also now, first appeal and order is passed, you cannot file. That is not available for you. Be cautious. Then what is next would be section 104. Section 104 is akin to order 43 because these are orders against appeals against orders. Then immediately turn around. What is an order? What is a judgment? We all know, maybe I'm only blessing your memory, you all know it. Difference between an order and judgment. A suit, if it is finally decided, it's a judgment and decree will be there. It's a mandatory. Every suit, judgment coupled with decree, a decree should be drawn in consonance with the judgment. Then, sir, order 43, you said, it's not an order. Yes. When we file an suit, we file a interlocutory application. Let us assume we file a declaratory relief suit. There we wanted an interim protection like we do miscellaneous petition IS here. There, in the suits, they file an application under Order 39, Rule 2, restraining, add interim injection or any injection they want. Then injection is granted or declared. That is an order and decree. That is an appealable order. That is not a revisable order. It should be dealt under the provisions of 104 coupled with order 43. Then comes, all of you know this, 115 revision. We day in and day out, we deal that. Now, recently, maybe around, if I'm right, 2009, Honorable Supreme Court said, I'm not giving you judgments because, as already said, listen it, don't write. You will be gaining only bird's eye view. Tomorrow you will be definitely doing work on this. Day in and day out it comes to you. It's not as though that you are not aware, but we are only meeting it, we are interacting it with you. It's my pleasure to interact with you. My pleasure to exchange words. You have better knowledge to me. You can definitely come. I am open. You can appraise. Come when a point comes in the court. Point does not come open. We are all learners. We are in the same school. Day in and day out, definitely yes, you learn better than us. You are in the society. Now that from the past 1 year, I am in the chambers. You are in a wider place. So we are all learners. Then we revision is revisable, any application filed. Finally, what I was referring is Supreme Court, Honorable Supreme Court said, under 115, if an order is totally coming under the purpose of revision only, you file 115. That is amounts to final order. 115 you invoke. Then immediately your mind will be going to what is that filed under 227 of Constitution of India. Those are both same, but under 115 you have got broader. That is a revision. 115 you have got a better remedy. Every order is not revisable, which has decree is revisable. Then 227, any docket order also can be revised. Supervisory jurisdiction to correct some illegality by the learned trial court. You are open. 227 we file what we call CRPs, goes before a portfolio judge, hears it. Then the docket orders or any docket orders will be corrected. Then under 119, we are all lucky because day in and day out, many party in persons come to us. They file a writ petition, but they argue differently. That is the reason 119 is a specific bar prohibiting any unauthorized persons to address the court. If that is there, we are all not there. I include yourself in you. We are all not there. We are different class of persons. We are governed by Advocates Act. An advocate from official court, from junior civil judge court up to Supreme Court, studied the very same LLB. He can appear from junior civil judge court to Supreme Court, provided you get a case. We're all same class. There is no distinction between trial courts or High Court or Supreme Court. Walk into the Supreme Court, can file a case, provided their rules are different. They should be filed by recognized advocates and records, but you can argue the matter. So that is the reason section 119, all these things, what we listen outside, are very much governed by the procedures. Every rule, what we do here, your Advocates Act came into only section 119, was promulgated. As a class of advocates, you are permitted to enter the courtroom, walk in, see the court proceedings, argue the matters by filing a wakalat. But a party in person or any other person should seek permission of the court. He will be placed before the committee. Committee should give him the permission thereafter only. Coming little bit, Asha, because maybe I'm taking much time out of you. Then under 123, High Court has got some power. It makes rules because for
Now comes what are pleadings? What are pleadings in a when we go to the file a claim? What are the pleadings? One is the claim. One is the written statement.
So when you plead all the facts properly. Plead the facts properly, and every fact, when you are coming with a fact, plead it specifically. And when you're filing your plaint, don't go to evidence part. Never disclose your evidence part. You file a plaint, say that, sir, I have I have purchased this property from the rightful owners, why the distinct sale leads, who has purchased the same from the rightful owners. That's it. You need not say, I have purchased from XYZ, XYZ has purchased from ABC, ABC has purchased from PQR. You need not say. You simply say, I have purchased this by a distinct dealer who in turn has purchased from the valid. Then comes when you find Order 18, Rule 4. Affidavit, you disclose all those, mark the documents, but never disclose your facts, evidence in your plaint. Then Rule 4, when you are dealing Order 6, Rule 4, always remember when you say the defendant has misrepresented and committed fraud, that should be stated in your pleadings unequivocally. You specific say that yes, defendant played a fraud, misrepresented the facts. Therefore, the suit has to be declared. Even in your written statement also, when you take such defense specifically, then comes Rule 15, all you know, even in affidavit also, we say that verification is important. It's a procedural one. Maybe time and again court said procedural one, you need not harp upon that, but mandatorily the verification should be very much there. Then comes your written statements. This is also important for the defendant. Specific denial should be there. If the plaintiff says he has purchased from rightful owners, you deny that. Say that the assertion of the plaintiff is not proper, is not true, it is false. He has not purchased from the vendors, where rightful owners. His vendor has no title to the property. Say that, that is specific denial. Everything. For example, there is a new fact. You say, I am also the owner. Order 8 says, I am the owner. I am the patedar. You draw your inferences from 54 Kasra to 1B, ROR, Namuna, whatever it is, your documents, read specifically. Then another important thing is, for example, we do mistakes. Yes, because party doesn't give you information and he comes in the midnight, tells us to file a suit in the morning because he says, sir, if you don't file a suit today, property will be sold. Or some way or the other, he shows some urgency. If we file a suit, summons are issued, or written statement, the defendant comes, files a written statement due to inadvertence, maybe non-application of mine. Then would be you file Order 6, Rule 17. Important issue is here. When can you file an application under Order 6, Rule 17? Can you file when trial has begun? No. Order 6, Rule 17 says the application should be filed before the trial begin. Then trial beginning, I need not tell you, you're aware of the fact when the trial is set to be begin. After issues, the defendant or the plaintiff files his affidavit in lieu of chief examination, then the trial starts. After that, you can't file. But there is a proviso which says that you can do, provided you should state the facts for non-filing of said application with due diligence. The court can take its discretion decision, extend the discretion, allow the said application, then additional written statement or rejoinder, what you call, will be filed. One more important aspect I would tell you here. You file a plaint, written statement is filed, their rejoinder is filed. When rejoinder is filed, for example, we'll see a suit is dismissed, rejoinder is also a suit. In a written statement, you can file a counter claim. What is that? Rejoinder come counter claim, or written statement come counter claim. When you file a counter claim, the suit is dismissed, but counter claim is allowed. Let us think in that way. Then you file an appeal. Then can you file one appeal or two sets of appeals has to be filed? Because counter claim is also a suit that has been decreed. Plaint was dismissed. Then Honorable Supreme Court recently and also their number of judgments said one appeal is very much maintainable. The plaintiff can as well challenge the dismissal of the suit, can as well challenge the counterclaim in one appeal, provided the grounds should be very distinct. The grounds of attack, dismissal of the suit should be there. The grounds of attack and the allowing of the counterclaim should be also very distinct. And two sets of court fee has to be paid. One appeal is maintainable, definitely yes. When that appeal comes, the first appellate court will decide that. But be cautious when counterclaim is filed. Then what happens if a party, for example, if a defendant is served, if defendant is served, I'm sure I'll be completing in 10-15 minutes maybe. I didn't expect that I'll be addressing you this far, but I'll conclude within 10-15 minutes. I know you should rush to your office. Yes. Then what happens, sir? It is served upon the defendant. Defendant does not come to the court, doesn't engage any counsel, he doesn't file any defense. What will happen? With service of summons, he will set ex parte. Then if defendant realizes his mistakes, he goes to an advocate, say XYZ. Learned advocate immediately comes to the court, files an application under Order 9, Rule 7. Normally, if that application is filed, even if counter is filed, learned judges will allow it. Will give you time to filing of written statement. For example, even you don't go in time, the plaintiff will reap benefit out of that. You will file evidence under Order 18, Rule 4, lieu of chief examination. The suit will be ex parte decree. Then what would happen? There is one more provision, because these are all mistakes committed by the party. The legislative intent is very clear. We will be prone to, we are human, we will be prone to commit mistakes. One more opportunity for the plaintiff to file an application under Order 9, Rule 13. Then it's a decree. If the application has to, it should be filed within 30 days. We don't go to the court within 30 days. What would happen? We'll wake up after 6 months, go to the court, sir, was not well. So you file an application under Section 5. That's a different topic, or some other day, if I'm right, some other speaker will be dealing with that. Section 5 application will be filed along with an application to set aside. The learned judge feels that, no, this man has kept quiet all those for 6 months without any valid reasons. He has come to for this court, file his application. We cannot give him that right. Then what will happen? That will be dismissed. Section 5 will be dismissed. Consequently, what will happen? The Order 9, Rule 13 petition also stands negated, rejected. Then previously we used to challenge Section 5 litigation by filing a CRP. Honorable Supreme Court recently, Catina of Judgment said, since consequently the Order 9, Rule 13 petition is also dismissed because it's an Order 43 appeal is maintainable, both clubbing together, you can file an appeal, what we call a civil miscellaneous appeal. Then an application is Dismiss for non-prosecution, we all know. Same thing, we go file an application order 9, rule 9. Then one more impact, order 12, rule 4. Sir, the defendant has accepted that I am the owner. What more is there, sir? Some provision should be there. Unless there is a provision, the court will not decree. That comes order 12, rule 4, facts admitted need not be proved day in and day out. If counters are there, if the counters are filed admitting we normally will say that yes, you have admitted what remains. We'll dispose of the we'll allow the writ petition. Then I already stated order 18, rule 4, evidence now. Previously there was a cumbersome procedure where the party goes to the court. He deposes, chief examination. It will be recorded by the learned judge, presiding officer there. Thereafter, what will happen is, now rule has changed. We can file an affidavit in lieu of chief examination. Advocate commissioner will be appointed by the learned presiding officer. Thereafter, cross examination will be recorded, typed and filed before the court. That is one more. Then all the other things, judgment and decree, I told you, order 20. Important point is 21, execution of decree. This is definitely a cumbersome part of a civil litigation. You all know how far it will go. Sometimes it will also go more than the suit. The suit is tried for 5 years, 6 years. Appeal takes 4 to 5 years. Then second appeal takes maybe lesser time. We are dismissing now because if there is no substantial question of law, the very purpose of maintaining that appeal, because the plaintiff or the person who has suffered in both courts should not be again admitting it. So 100 CBC is very clear. Number of judgments are there. If doesn't make any substantial question of law, as you know, we'll be dismissing. Then order 21, it's taking much time. That should be famous. Legislative intent should change. Maybe we are not, procedure doesn't. There are judgments where Honorable Supreme Court said when EP is filed, it should be addressed maybe around 6 to 1 year, but that is not possible for the learned trial courts, maybe because many issues are there. Petitions are being filed, has been dragged. Next would be order 39. That's a simplest, a suit. What we call bail here. We file bails here. Normally juniors will be enthusiastic to file a bail because very, very short contentions can be raised in a bail. Same thing, 39 will only say prima facie title, balance of convenience, irreparable loss. These are only 3 things. You file a suit for perpetual injunction, restraining the defendant from ever interfering into your peaceful possession and enjoyment of the scheduled property. Then file an application under order 39, rule 1 and 2 for ad interim injunction. Thereafter complying 3, rule 3. If it is, you show prima facie case, balance of convenience and irreparable loss, normally a court will grant that injunction, that you are aware. Now, I already pointed out to you, 96 coupled with 41. Friends, please go through 41 whenever you find time. It's a procedural code. It will answer your point. Everything is there. Self-contained procedure. Normally, we'll only file the appeal under section 96. We'll leave it. How an appeal has to be dealt, it's properly explained. Maybe paucity of time I had prepared in that, but maybe I'm leaving it to you. One important issue is when you don't deal, for example, appeal, you file it, appeal has been being postponed for 4 or 5 years. There is no response from the appellant, defendant or appellant plaintiff is not coming forward for arguing. One provision is 41 rule 17 where if the appellant is not reporting or not ready with the arguments. What we say in disputes for non-prosecution, same thing there is also there. 41 Rule 17 we can pass. Thereafter you can file applications, no doubt. Then there are number of provisions, review all you know. Then chartered accounts, chartered high courts have been deleted. Provincial small causes courts are there, where value of the matter is less than 25,000. And presidential small causes, definitely now it's not there. We'll move on to next topic. It's a specific relief act, very short act, but very what we call substantial act, because we file suits under the CPC. What is the relief? Unless you properly pay the relief, can the suit, I said, A wanted to marry B, can a suit be filed? No, there's a bar. You cannot compel. It's opposed to public policy. Then what? To deliver a possession of the property. How should you file? So, Section 4 deals of the specific relief act deals with enforcement of a civil right, not for enforcement of a penal law. Can you file a suit for enforcement of a check? No, because check has got altogether a different field. It's a under the Negotiable Instrument Act, what we call NI Act. It's a penal provision. What we say, it's a quasi-judicial, quasi-criminal, quasi-civil. There are provisions since there is a bar. Next, 5 to 7 of the Act deals with specific performance of agreements. You enter into an agreement of sale with some XYZ for purchase of the property. Remember, when you draft that agreement of sale, be cautious. You write it in such a way, the sale consideration part, then when it should be executed. If time is not stated in that, specifically when you draft an agreement of sale, be cautious. You say that the vendee has to pay the sale consideration within such time as you both agree. Failing to perform, you put a rider, be cautious. Failing to perform, the agreement stands cancelled. Then only time will be the essence of the contract. If you mechanically draft it, don't put that condition. Time and again, Honorable Supreme Court is coming heavily, saying that normally in an agreement of sale, time is of an immovable property. Time is not essence of the contract unless the parties covenant specifically. Therefore, when a client of you comes to you, you should do justice to him, because it cannot be protracted for years together. I want to sell a property. I should say 2 or 3 months I'll be getting the money. He takes advantage, he doesn't pay. He only comes, gives me 10,000 token advance. He doesn't give me balance sale consideration. I didn't, the advocate, whatever it is, I take, still I'm in your role, and we are social engineers. We have got social responsibility. The clients come to you with belief on you. He has got utmost belief on you. He believes you. I have been telling, an advocate is not less than President of India and not more than a common man. Same time, both responsibilities we have. So tell him that if the sale consideration is not paid within 3 months or 6 months or 1 year, the agreement stands cancelled and the so and so consideration will be forfeited. Maybe if it is not 5 lakhs, if it's 5 lakhs is paid, you cannot retain 5 lakhs totally, but a part of that can be forfeited towards a damage. If that is there, then to file a suit under provisions of Specific Relief Act, there will be a bar for him. Even if he files, you can say, sir, there was an intention to sell the property, but the plaintiff has not come for to perform his part of consideration, perform his contract within the stipulated time. There was a condition. That is condition is the president. Therefore, Since within 3 months he has not paid the sale consideration, yes, he does not have any right. The agreement stands cancelled. You can take straight away decision. That is very important. Please, when you draft an agreement of sale, be cautious. Next, maybe there are number of provisions here. One important provision is section 16C. For the specific performance suit, A enters into an agreement with B. B says, I'll pay A 5 lakhs within 3 months. Failure to pay if you don't say. Time is not essence, but previously pre-amendment before 2018 16C says the plaintiff should definitely say, aver and say. You should aver that I was ready to perform my part of consideration. Despite the same, the defendant has not executed the sale deed. I was always ready and willing to perform my part. Therefore, I am before this court filing this suit. Please, this is a relief. Please grant me. Time and again, Honorable Supreme Court has been saying the plaintiff is constantly, from the date of signing the agreement of sale, he should be ready to pay the balance sale consideration. Post amendment, one word, aver is removed. Even if you don't say that I'm ready, but if you prove that you are ready to perform the agreement always from the inception of the agreement, then you are entitled for such relief. One more, section 20 and 22, both are akin of the same. Please be cautious. Somebody gives you enter into 5 lakhs. Somebody gives you 10,000 rupees, paltry one, promises to pay it, you did not write any condition, 3 months or 6 months, no forfeiture clause, no cancellation clause. Then you go to the court. Then when it comes before the presiding officers, let us assume it goes to the land trial court judge, because specific relief is an discretionary relief and equitable relief. Therefore, 5 lakhs, where is 5 lakhs and 10,000? You did not pay it for 1 year. Are you entitled? Then Honorable Supreme Court said, it should hit the conscience of the court. The conscience of the court should be satisfied. Justice should be done. 10,000 he has paid. 5 lakhs was done. Had he paid substantial amount, 60,000, let us think 60%, 70%, say 3 lakhs, 4 lakhs, then he will be entitled because substantially he has paid. But giving 10,000, that is also an equitable and discretionary relief. And one more, when we go to section 34, maybe this 34 is much helpful to you because you file a suit for declaration, no consequential relief, or you file a suit for partition, no consequential relief. You only said, sir, I should be awarded 1/6 of the share in the property. You did not pray to be delivered, separate portion should be delivered, you did not pray. The conducting of such suit, there is a bar under section 34, because what would happen if partition is already granted? Let us assume relief is granted 1/6. Unless you get 1/6, where is the question of declaration? So be careful. One more suit, simply don't file recovery of possession. Always file declaration of title, consequential injunction, or if you are not in possession of the property, pray for recovery of possession. These are two fin conditions. Neither you can file a declaration title without consequential relief, nor you cannot seek only consequential relief without the major relief. So be cautious. Maybe it has been 6 o'clock. I'll only take 2 minutes because One important is transfer of property. Without property, there is no civil proceedings. Most of them, we can say, if I'm right, all will agree with me. I'm sure, madam, you are now definitely tea time for all of us. We'll definitely finish it. So without property, there is no civil. Normally, there are suits where mobile properties are there and tangible assets, different assets are there, different suits are there. But normally, 80% without property there is no. Then you know how the title passes, chain of documents. What is a sale? Section 54 says, what are the modes of transfer? Definitely yes, mortgage, lease, sale, and such other things we are there. Exchange is also one of the mode. I give this property to you. In turn, you give me this property, that is exchange. So one more issue is transfer of property suit. Lease pendants is most important. Section 52, there are number of sections, but I'm just restraining myself. Section 52, you file a suit against defendant. In between the proceedings, the defendant sells it to XYZ, he parts with the property. What would happen to the right of the plaintiff? Then section 52 will come to your rescue. In the event if you succeed in the suit, then that property will be reconveyed to you by the defendant. And one more thing is, you should make the subsequent purchaser also part of the suit, so that tomorrow he should not say, I'm a bona fide purchaser, because one of the ground available under section transfer of property, section 53, is a bona fide. Normally we'll call it, I'm a bona fide purchaser. Under what law you are bona fide purchaser? 53 says, where 53 says fraudulent transfer. Fraudulent transfer is void, provided the transferee has purchased bona fide. That is the ground available for a bona fide, because it says, sir, I was not available about the suit. I paid such and such an amount. Bona fidely, I believe that the property is not with any litigation, so I have purchased this. Therefore, I am a bona fide purchaser. All things are there. So, what would section 122 gift? You are very conscious, day in and day out, gift will be there. Gift is the only instrument where document is valid without a consideration. What is a consideration for a gift then? Love and affection, which all we know. Then how should a gift be valid, sir? 3 conditions are there. Gift should be registered, right? Hindu law I am speaking. Maybe Muslim law, oral hiba is also permissible there, because the succession is matruka only after the death. Pending is not there. But we have joint family. We, in the sense, Hindu law has recognized joint family, but there is no joint family status there. Only it's all matruka after the demise of the person whom there are certain uncodified Shias and Sunnis, they have different, but so far as Hindu law is concerned, gift should be registered and it should be delivered. Possession should be delivered to the donee. And one more thing is, gift should be accepted. Therefore, when you are drafting, you do draft, yes. An advocate, definitely yes. Some point of time, normally they'll go to sub-registrar's document writer, but an advocate drafting will be different. When you draft, friends, we draft in such a way, so and so is the owner, out of love and affection has gifted. The donee has accepted the gift. In token of this acceptance, the property has been delivered to the donee. on this day, before the following witnesses should be there. It will make valid, even if any person goes after that. Once it's accepted, it's valid. If there is no acceptance, if there is no delivery possession, the gift becomes invalid. Even rights are also not there. So be cautious when you draft agreement of sale, gift deed, and all that. I just thought to tell you it's not a lecture. You're all learned people. As already I addressed you, it's only interaction with you. It's my pleasure to come to this esteemed association. Time and again I'll be coming. Time and again I'll be coming. Maybe you have less time. We will adjust our time somewhere down the line. Friday, probably everybody will be in a joyous mood. Maybe the president said, sir, if you come, you will be definitely taking much time out of our advocates. Only time we have on Friday is go home, spend time with family, or wherever it is with our friends. So don't come on Friday. Then I thought, for us, Monday to Sunday is same. There is no Monday or Sunday in our calendar from at least from 31st July 2025. And Sunday also we prepare because you are mightier. We prepare for you to come before us, to tackle you. We should convince you. We cannot, you can shout on us. Yes, you got that right. Where you can shout. You will not yell outside, you will not shout outside. Can you do that? No advocate will do that. But you will only fight in the court. You fight for a cause. Fight for your client. Fight for the person who comes to you. Lord Krishna has fought with Arjun. Then advocate is no exception for that. Fight with the judge. Decent way you fight. Win. You will win with the reason. And I extend all the greetings for having a patient hearing. Maybe the topic I selected was from the beginner's point of view. Even I am also a beginner. I started my maiden interaction with you. Before that, I didn't have any interact section. Maybe a secretary, vice president, I was addressing the gathering. That was in different role. That I was not sharing my thoughts, but I was only delivering some address. Delivering an address is not that, is definitely easy to imbibe certain thoughts into your precious minds, taking good time out of you. Once again, I thank you one and all. I thank the president and his wonderful executive team for calling me, having an interaction with you. Thank you one and all. Thank you very much. Yes, I am ready to take questions provided you have time. I don't mind, but for me, I already told you. Yes.
So that is challenging in the circumstances where the donor wants to be the donor on the donor. When this happens, when can this be challenged?
Yes.
Can it revoked?
Yes. No. One thing, gift once executed cannot be revoked. The proper course would be file a suit for cancellation of the gift deed, saying that under coercion and threat, the gift was executed. Under misrepresentation, the gift got executed. There was no delivery position. There was no acceptance. And one more thing is, gift should not be onerous. For example, if I give something to my daughter, it should be, the property she should enjoy. There is a litigation on that. There is some maybe attachment on that. The gift is void. You don't cancel it. You can file a cancellation of the gift deed by instituting a suit. Time and again, number of judgments are there. I thought to take the judgments also, but what would happen is interaction will go. It will go like a lecture. I just thought to learn. Yes. 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 When you file a when you file a plaint, never go with evidences. You invite the written statement of the reply statement of the defendant without an evidence. Don't disclose that evidence before settlement of issues. If he disclose the evidence, the defendant will definitely go to a clever advocate. He will be pleading in such a way that he will invent some ways. So never give evidence in your plaint. Always our only pleading should be said concerns precisely. That's all. Not more than. Thank you, Bernardo. Thank you.
Thank you, sir, for enlightening the members
Yes.
on this topic. I request our Joint Secretary, Ms. Krishna Gupta, to propose vote of thanks.
On behalf of Telangana High Court Advocates Association, I deem it's a bit privilege to propose vote of thanks. I thank Honorable Justice Sudala Chalapati Rao Garu, Judge High Court for the State of Telangana, for graciously accepting our invitation and addressing this gathering. I thank your lordships for sharing your vast experience and enlightening the members of the bar, particularly our young members, on the provision of Civil Procedure Code, Specific Relief Act, and Transfer of Property Act from beginner's point of view. I thank members of the bar and legal fraternity for attending the occasion and making this gathering eventful. Thank you one and all for gracing the occasion. I request and the members to please join for high tea. Thank you.
You are all.